have your books, read it, take down notes. The secret of learning law is when you read a certain law and you do not understand it, do not go to the next. You research, you study, you research on that law until you shall have understood it before you go to the next. Because studying law is not like reading comics. You read a page in comics and you don't understand it. You just go to the next page. Maybe you will understand later. No. When you study law, you have to understand the provision before you go to the next. If you don't understand, research, ask questions. It is only when you have fully understood the provision when you can go to the next provision. Okay? So we have an example there which I would like to explain because this is a very good example. The case of Kyoke versus Bautista. Kyoke versus Bautista. Q-U-I-O-Q-U-E. Kyoke versus Bautista. In this case, here is a person who went to the bank, obtained a loan. The bank will not give you a loan without any collateral. So, what the person did, he used his parcel of land as collateral to the bank. Condition that if he cannot pay his loan, let's say of 1 million, the bank will foreclose the encumbered collateral, which is the parcel of land. Now, the loan is for, let's say, 5 years. 5-year period expired, the person was not able to pay it. What the bank did, the bank filed a case of payment of money worth 1 million plus damages against the person who loaned, and filed another case for foreclosure of the mortgage parcel of land. Well, it reached the Supreme Court. The Supreme Court said, bank, you cannot do that. There is only one cause of action, the indebtedness secured by a mortgage collateral. Now, if the conditions are not hidden, the loan is not paid, you can either file a case for collection of a sum of money, the indebtedness,
sige, Insan, salamat kayo.
Or file a foreclosure of the mortgage in order to get the encumbered mortgage parcel of land. That's all, because there is only one cause of action, the non-payment of a loan. So in this Kyoke case, the Supreme Court applied Section 3 and Section 4 of Rule 2. There can only be one suit for a single cause of action, and there must be, if there are two or more, if it is split into two or more cases, then the others may be dismissed, and only one remains. Okay. Now, Section 5. Joinder of causes of action. A party may, in one suit or pleading, either in the alternative or otherwise, as many cause of action as he may have against the opposing party. A party may, in one pleading, assert or include in one pleading, in one case, as many causes of action as he has against another party. Now, kindly take note. A person who has a single cause of action cannot split it into two or more cases. But a person who has two or more causes of action can file only one suit, which includes all the causes of action against the same party. You see? Nikyoki case, the bank cannot file a case for collection of a sum of money and then file foreclosure. There is only one cause of action. So he can only file one suit. Now, here is a person who went to the bank, borrowed 1 million, then have, let's say, collateral, a parcel of land. And then, months later, he again went to the bank, borrowed another 1 million, and then gave another collateral. So there are now two causes of action if both indebtedness are not paid. Question: when both matured and the bank was not paid for the two loans, can the bank file only one case which includes the two loans? Answer: under Section 5, yes. Why? A person can join two or more causes of action in one suit. A person cannot divide a single cause of action into two or more cases, but a person can join two or more causes of action in one case. The reason here under the Supreme Court, in the case of Baldover versus Sante, is that the Supreme Court would like also to encourage multiplicity of suits. Multiplicity of cases. If one case can be filed joining causes of action between the same parties, then it could be done. It could be done. Baldover versus Sartre. But in this case, the Supreme Court said that this rule is permissive, not mandatory. Meaning, it is now the choice of the plaintiff whether he will file two cases for the two loans which are not paid, or he will join the two loans in one suit. That is permissive, not compulsory, not mandatory. Okay, one more thing before we go to the next. A joinder of two or more causes of action is not available all the time. It is only available when the conditions enumerated in letters A to D are available. If the enumeration under A, B, C, and D are not available, you cannot join two or more cases, not two or more causes of action in one case. So what are these four conditions? Number one, the joinder, the causes of action shall comply with the rules on joinder of parties. Meaning, there is under Rule 3, particularly Section 6, there is a rule which allows joinder of parties. We will study that very well, but just to give you a purview, you can join two or more parties in one case. You file a case against A, against B, against C. In one case, you join them as party defendants if, number one, there is a common question of law. Number two, if there is a common question of fact. You can join the parties. Now, if you can join parties because it is in accordance with the rules, you can also join causes of action under letter A. Letter B, the joinder of the causes of action should not include a special civil action. Take note that we are studying ordinary civil actions. So if you have an ordinary civil action against this person, and then against this person you also have a special civil action, can you join them? No. No. There is only available joinder if both causes of action fall under ordinary causes of action. Letter C, if the joinder belongs to different jurisdiction or venues, can it be done? For example, you have a cause of action against A, in which, because it is just a small amount, the jurisdiction belongs to the MPC. You have a cause of action against B, the same nature. The same nature. But the amount is big. So the jurisdiction is with the RTC. So one MPC, one RTC. Can you join them? Different jurisdictions. Answer is yes. And the letter C, but the case must be filed in the higher court, which has jurisdiction over one cause of action, not in the lower court, which has no jurisdiction over one cause of action. Okay, letter D, if the two or more causes of action are money matters, let's say filing a case against A for 10,000, then the same case, the same nature against B for 20,000, against C for 30,000, against D for 40,000, the same nature, the same reason why they are incurring the indebtedness, you can file it in one case. Join the causes of action. Now question, what will determine jurisdiction? One debt or the aggregate of all the debts?
No, sorry? Sa Kalahari office. Niya inaasa Pastor George. Sige. Ano? Kato nang may sidling?
Oo, nasa.
Pila na to?
288, sir.
Ay, Wala sa
Nakakita ka? Kung Domingo, sir, wala ka niya, sir. Sabado Domingo.
Ano naman? Yan.
Usahay kayo, ako may tigugan. Nakakita.
Sige, sige.
So you add all the debts, and then that will determine a cost. Let's say you will know later on that the jurisdiction of the NPC is only up to 100,000 pesos. Over that, RTC na. So there are three debtors, same character, but one is 50,000. The other is 100,000, the other is 100,000. So, where do you file it? NPC. You add all the debts, so that's 250. It belongs to the RTC. That is the rule. These are the rules on joinder of causes of action. To repeat, you cannot split a single cause of action into two or more cases. But you can join two or more causes of action in one case, as long as the conditions under Section 5 are met. Now, the last section in Rule 2 is misjoinder of causes of action. There are two or more causes of action, but they cannot be joined. Now, you filed only one suit and join them. What happens? The court will not dismiss the whole of the suit, but the court will just sever those causes of action which are misjoined. So it does not result to dismissal, but it results to severance of the cause of action which is misjoined to the main one. Okay? So that's Rule 3. And we end up here, we will go to Rule 2, causes of action. And we will go to the rule on parties next meeting. Thank you very much and good day, everyone.
Dikit ko sa'yo yun, Day. Watching pa.
Good afternoon.
Ay.
This is an e-lecture, a continuation of our lectures in civil procedure. The last time we met, we were discussing rules 1 and 2. Now let's go to rule 3. Which is a long one because it is composed of about 22 sections. Let me see. This is composed of 22 sections. So it's rather a long one. This is on the parties to a civil action. Who may be parties to a civil suit. Now remember that what we are studying in this subject is ordinary civil actions. So the parties that we are going to study here are parties to an ordinary civil action. Just by way of review, actions may be ordinary civil action, which may either be ordinary, then special civil actions, then criminal actions, then special proceedings. You know the definition of all these things. Now, the parties that we are going to discuss here are the parties to an ordinary civil action. But so that you will not be confused, I will just mention in passing the other parties which are applicable to other actions, not ordinary civil actions. Such as in a criminal case, the complainant, the person complaining, once he filed his case with the police or with the fiscal's office, the person complaining is known as the complainant. And the other person who is charged by the complainant in a criminal case is known as the respondent. Complainant, respondent, if the case is still filed with the police or the fiscal's office or the prosecutor's office. Now the prosecutor makes an inquest to determine whether there is a probable cause. As we have said, if there is none, the case is dismissed. If there is, the court, the prosecutor's office, the fiscal's office, will file the information. The information is a complaint filed by the fiscal's office in a criminal case to the court. Now, in the information, the parties would already be the people of the Philippines versus the accused. The complainant is already known as the complaining witness because in a criminal case, it is the state who is the real complainant. So people of the Philippines against the person who was called respondent in the fiscal's office is now referred to as the accused. The accused. So the group of the complainant is known as the prosecution, while the group of the accused is known as the defense. That is in a criminal case. In a special civil action and in a special proceeding, almost always, I say almost always because there are exceptions which you will know later on, almost always in a special civil action or a special proceeding, the person who is making the complaint is known as the petitioner. And the person against whom the pleading is filed is known as the respondent. So petitioner, respondent. Sa criminal case, prosecution, defense, or complainant state versus the accused. So, in special proceeding, the same, petitioner, respondent. In an ordinary civil case, the parties are, the person filing the case is known as the complainant, the plaintiff. Complainant in a civil case, ordinary civil case, is known as the plaintiff. And the person against whom the case is filed is known as the defendant. Plaintiff, defendant. So, when you receive a pleading, you receive, let's say, a client, and the pleading says petitioner versus respondent, you will not ask what kind of case is this. That could either be a special civil action or a special proceeding. If the pleading says people of the Philippines versus accused, you will not ask what kind of case is this. This is a civil case. But if the pleading says plaintiff, Juan de la Cruz plaintiff versus Pedro Santos defendant, then that is an ordinary civil action. That is what we are going to study now. That is why under section 1, it says only natural or juridical persons or entities authorized by law may be parties to an ordinary civil action. The term plaintiff refers to the claiming party, while the term defendant refers to the party against whom the claim is made. So, the person suing is the plaintiff, the person sued is the defendant. Now, if you notice, there are still terms included in section 1, like counter-claimant, cross-claimant, third or fourth party plaintiff or fifth party complaint. Plaintiff. Then sa defendant, there are also counter-claim defendants, cross-claim defendants, or third party defendant or fourth party defendant, etc. Now, you will not understand this if you know what is a counterclaim, cross-claim, or a third-party complaint. Okay. Listen to this very well. Mr. A filed a civil suit against Mr. B. Now, Mr. A filed what is known as the complaint in a civil case. He is the plaintiff. Mr. B is known as the defendant against whom the case is filed. Now, under the law on pleadings, which you will know in the next rules, when the defendant receives a complaint, he files an answer, a pleading known as an answer. So plaintiff files a complaint, defendant files an answer. Now there are, in the answer, in the complaint, the plaintiff alleges all his claims against the defendant. In the answer, the defendant alleges all his defenses against the claim of the plaintiff. Now, there are times when in the answer of the defendant, he also includes a claim against the plaintiff. He might say, well, plaintiff is claiming that I am indebted for 1 million. But he is also indebted to me for 1,500,000. So why should I pay the 5 million? But he has to pay the 1 million, but he has to pay the 500,000. So there is, in the answer of the defendant, there is a claim against the plaintiff. Now that claim is known as a counterclaim. Counterclaim. So When A files a case against B, that is the plaintiff, and B is known as the defendant. In the answer of the defendant, if he includes a claim against the plaintiff, then the defendant made a counterclaim. And in regard to that counterclaim, the defendant becomes the counterclaim plaintiff. And the plaintiff becomes the counterclaim defendant. Okay. Now, cross-claim. Dahil itong counterclaim, cross-claim. A cross-claim is a claim supposing A files a case, plaintiff, against B and C defendants. He filed a case against two persons, B and C, alleging that B and C are indebted to him for 1 million. In B's answer, B said, A is mistaken because it is not I who is indebted to him for 1 million, but it is C, my co-defendant. In other words, in the answer of Mr. B, he is alleging a cross-claim against his co-defendant. That is a cross-claim. So when B made a cross-claim, B is the defendant cross-claim, cross-plaintiff or cross-claimant. And C is the defendant cross-defendant. So you see the difference in a counterclaim. The defendant interposes a claim countering the claim of the plaintiff. In a cross-claim,
Yes, ma'am. Na-receive ko na. Okay.
the defendant is countering a claim not against the plaintiff but against his co-defendant. That is a cross-claim. Okay. What is a third-party complaint? Mr. A filed a case against Mr. B. So A, plaintiff, B, defendant. In the answer of, there is only one defendant, In the answer of the defendant B, his defense is, Mr. A, it's not I who is indebted to you, but Mr. C, who you do not make as a party. So, in other words, what defendant B did is bring another person to the case. Therefore, Mr. B is known as the defendant, third-party plaintiff, and Mr. C is a third-party defendant. Take note of the distinctions between the three. First, counterclaimant, claim by the defendant against the plaintiff. Next, cross-claimant. by the defendant against his co-defendant. Third party complaint, claim by a defendant against a third party who is not included by the plaintiff in the case. That is a third party complaint. Now, if Mr. C, the third party defendant, will claim, will say in his answer, it is not I who is liable, it is Mr. D. He brings another party. Then that is a fourth party complaint. And Mr. C is a fourth party plaintiff, Mr. D is a fourth party defendant. Okay? Kindly repeat this part of the lecture over and over again so that you will understand. I will suggest that in your notebooks you make an illustration, some sort of figures, so that you will understand very well what is plaintiff, a defendant, a counterclaim, a cross-claim, and a third or fourth party complaint. Okay? That needs analysis and mastery. So you see, if you think that you will just read the law and that's it, you are dead wrong, because it needs an explanation. These are explanations which are practical and which is not so explained in the book. Okay. Now, before we go to section 2, let's continue with section 1. The law says, who may be parties? Plaintiff and defendant, only natural or juridical persons. Generally, may be parties. In our law on persons, we discussed the topics on natural persons, you and me, natural beings, and artificial persons. Those associations, partnerships, and corporations which are given juridical personality by law. They are known as the artificial or juridical persons. Therefore, a corporation can be a plaintiff. So you can see in cases like Star Corporation versus Juan de la Cruz. Star Corporation plaintiff versus Juan de la Cruz. Why? Because juridical persons may be parties. So a juridical person may also be a defendant. Juan de la Cruz plaintiff versus Star Corporation or Moon Partnership defendant. Okay. Now, I said generally natural and juridical persons may be parties because there is another one which can be made as a party because the law so allows. And this is what the law says: only natural or juridical or entities authorized by law may be parties. Now, these entities are not juridical persons, but because the law says so, they may be parties, whether party plaintiff or party. The best example is this. When a person dies, all his properties will be brought together, known as the estate of the deceased person. His personal properties, his real properties, his money in the bank, his bonds, or his investments, all brought together, and it is known as the estate of the deceased person. Now, the estate of the deceased person will be divided and distributed by and among the heirs of the deceased, but it can only be divided and distributed if it is already a clean estate. What do we mean by clean estate? If the person who died has debts, part of the estate will have to be used to pay the debt, after which the estate is clean. Or on the contrary, if the person who died has many credits, then when he dies, the estate, before it is distributed, will collect all the credits from its debtors. That is, again, the authority of the estate by law. Okay. Now, who will do these things before it is distributed? If the deceased left a will, the law on wills and succession provides that in every will, in order to be valid, there must be a person appointed by the deceased in the will to execute his instructions. That person is known as the executor. So the executor will clean the will before it is distributed by and among the heirs. If the deceased did not leave a will, did not leave a person to take care of the estate before, thus making it clean and to distribute the same, then the court will appoint a person to do the job. And that person is the administrator. So executor, person named by the deceased in the will. Administrator, person named, appointed by the court to take care of the estate. The estate then, when it is clean, or even before it is clean, but when the person, the owner of the estate dies, the estate can file a case against its debtors. In other words, the case would be estate of deceased Juan de la Cruz versus Pedro Santos. Or, if the estate is indebted to Pedro Santos, the case would be Pedro Santos plaintiff versus the estate of deceased person Juan de la Cruz, defendant. What can be done? Because that is so provided in Section 1. So, if you are not listening to this, you're just reading the law, you think you can get it. That is the necessity, really, of listening to the explanation. Okay? These are so detailed that the authors cannot include that in their commentaries. That is why you have to come to class, virtually or physically, to study law. Gets mo? Feel mo? Gawin mo. That's Section 1. Okay? So let's go to Section 2 of Rule 3. Who will be the parties? According to Section 1, natural, juridical persons or entities allowed by law. But who are they? That's the question under Section 2. How will a person be qualified to be a party to a ordinary civil suit? And the answer is, under Section 2, parties in interest shall be parties in a suit, in an ordinary civil suit. Parties in interest. So the next inevitable question is, who are the parties in interest? According to Section 2, a real party in interest is a party who, number one, stands to be benefited by the judgment. Number 2, or who stands to be injured by the judgment. Here is a case. If it is decided in your favor, will you be benefited? Then you are a real party in it. Here is a case. You will be injured. Will you be injured by the decision of the court, which is against you? If you will be, then you are a party in it. Okay. For instance, you are holding your book now. That is your book, according to you. Well, here is your classmate who says, that is my book. Give it to me. And you say, no, that is my book. Okay. So, your classmate files a case. Against whom? Well, if the court says that is his book, you will be injured by the judgment. So you are a real party in interest. If the person says it's Mr. B who is the owner, then Mr. B is benefited by the judgment. So Mr. B is the real party in interest. Okay? So a real party in interest is the party who stands to be benefited or injured by the judgment. Or the law continues to say, the party entitled to the avails of the suit. The party entitled to the avails of the suit. And under the second sentence, unless authorized by law, exception daan, the rule is every action must be prosecuted, must be defended in the name of the real party and interest. So the question is, who can file a civil suit? Number 1, he should be benefited by a judgment, so he prosecutes the same, he is the plaintiff. Number 2, if you are going to be injured by an adverse decision, then you are a party in interest, and therefore you are a defendant. Now, who will prosecute? The plaintiff, who will be benefited. Who will defend? The party, who will be injured if there is a judgment against you. So, a real party in interest, repeat, is the party who should be there in the suit, whether plaintiff or defendant. Who are they? Those who will be benefited by the judgment, or those who will be injured by the judgment. And only real parties in interest may prosecute a civil suit or may defend a civil suit. Okay? Now, under Section 3, this is an exception where a person who is not a real party in interest may become a party. And that is if he only represents the real party in interest. So, here you are, second-year law student, you receive an SPA, Special Power of Attorney, from your sweetheart, giving you authority to file a case against somebody who is entering into possession of his parcel of land. Your sweetheart has a parcel of land in the Philippines, Now, here is somebody who is trying to enter illegally without authority in that parcel of land. But then, because of COVID, your sweetheart cannot come home. So he gives you an SPA, a special power of authority, authorizing you to file a case against this person who is going to intrude into the land of your sweetheart. So you file the case, not for yourself because you are not a party in interest, but in representation of your sweetheart, who is the real party in interest. So it's like this: if you are Mr. A, your sweetheart in the United States is Miss B, and somebody who would like to enter her land is Mr. X. So Miss B gives you a power of attorney to file a case against Mr. X. So the title of the case would be Miss B, represented by Mr. A, plaintiff, versus Mr. X, defendant. Take note that ikaw, you do not have anything to do with, you do not claim ownership or possession over the property, but you are filing the case in representation to you are filing the case in representation of your sweetheart, who is the real party in interest. That is Section 3. According to Section 3, a guardian, an executor, which you already know kung saan siya, administrator, you also know about already, or any party authorized by law through an SPA, an agent, a trustee, they represent the real party in interest. So we end up here and we continue next time. Take note that we are still in the topic on parties in interest. So thank you very much and good day, everyone.
Pasok po.
Okay na?
Balik na po di alas 2.
Sige, sige, sige na.
A lecture on civil procedure. The last time we met, we studied up to Section 3, Rule 3, which is talking about the parties to a civil suit, plaintiff, defendant, and who are these under Section 2, these are parties in interest. And to repeat, a real party in interest is one who may be benefited by a favorable judgment or who may be injured by an adverse judgment. Now, under Section 2, it says, the case should be prosecuted, filed by a party in interest, and defended by a party in interest. In other words, persons who have nothing to do with the case, who does not have any interest in the case, cannot be made parties to the civil suit. But we have the exception under Section 3. Parties who are acting in a representative capacity. He has no interest in this case, but since he is given authority by the real party in interest, then he can file or defend a case. But in filing or defending, he must name the real party in interest. Okay? That's a representative party. Now, we go to Section 4. Section 4, husbands and wives shall sue or be sued together, jointly, except if the law allows that only one of the spouses may be sued. So when you sue the husband, when you file a case against the husband because he is a husband, you must include the wife. And when you sue a wife because he is a wife, then you have to include the husband. Except when the case is personal to the husband or personal to the wife, then you cannot sue the other spouse. You cannot include the other spouse, but only against the spouse whom you have a claim. A good example is the law that you studied in the first year in the family code. If you file a case against a husband because he has incurred an indebtedness for on behalf of the family, you must include the husband and the wife, although it's only the husband who made the transaction. But family code further says that if the subject matter of the case is the exclusive property of the husband, then you do not have to include the wife, because the wife has no interest in the exclusive property of the husband. The same way, if you file a case against the exclusive property of the wife, you do not have to include the husband. In other words, a case which is personal to a husband is to be filed only against the husband. But if it involves the family or marriage, then you should include both of them. Section 5 talks about minors and incompetent persons. These are persons who are parties in interest, but by law, they cannot act on themselves. Why? They're either insane, incompetent, or minors. We have here a child who is a millionaire because he is a child star. Now, he is made to appear in a movie for a contract price of, let's say, 5 million pesos, but after the movie is made, he is not paid the 5 million, and this child is only 5 years old or 10 years old. So he has to file a case in court to collect the 5 million. How? He is a minor. So he has to file the case through a representative. Who are the representatives? According to Section 5, the father or the mother or both of them or the guardian of the minor if he has no parents. If he has no guardian, then the court will appoint a guardian of the minor or the incompetent only for the purpose of that case. That is known as guardian ad litem. Guardian during the litigation. Now, Section 6 is permissive gender of parties, which means the party is not a real party in interest, but the law permits him to be a party in the case. According to the language of the law, if the right for or against this permissive party arose out of the same transaction or with respect to the same transaction or a series of transactions, so that final determination may be had. Otherwise stated, it's like this. A permissive gender of a party is, we have said that only a party in interest can be sued or can sue. But the question is, can a person who is not a real party in interest be included in the suit as a plaintiff or as a defendant? The answer is, if it falls under Section 6,
Yes.
permissive gender of parties, then they can be included. And by the way, these persons who are not real parties in interest, who are not representatives, who do not have any interest in the case, but ought to be a party, ought to be included in order that complete relief may be had in the case, then he is to be included, and he is known as a necessary party. Take note, we have two terms here: indispensable party, without which no final determination of the case can be had; necessary party, without which the court can finally determine the case, but it would be necessary to include him in order to afford complete relief over the case. To explain what is an indispensable party and a necessary party, here is Mr. A, who is the owner of a house and lot. The house and lot is rented by Mr. B. B is not the owner, does not claim to be the owner. B is not, does not even claim to own the property, acknowledges that A is the owner, and therefore he is paying rentals to Mr. A as a leasing. Now here comes Mr. X, who is now claiming ownership over the house and land. He says, I am the owner of this house and land. The A said, you are dead wrong. I am the owner. So Mr. X, Mr. C goes to court, filed the case for recovery of ownership over that house and land. Against who will he file this case for recovery of ownership? Against Mr. A. Why? Because Mr. A is the real party in interest. He is claiming to be the owner of the property. Now, how about Mr. B, the lessee, who is paying rentals to possess the property for a period of time? Is he indispensable? No. Why? Because he is not claiming to be the owner. He is just renting the property. So he is not indispensable. So supposing Mr. C, knowing that Mr. B is only a lessee, files a case for recovery of ownership only against Mr. A, without including Mr. B, the lessee. Now, making the story short, Mr. C won the case. The court adjudged Mr. C as the real owner. So Mr. C goes to Mr. B and says, the lessee, and says, Mr. B, from now on, you pay your rentals to me because your contract has not expired. You pay your rentals to me because I am now the owner of the house and lot. Mr. B says, why should I pay to you? My contract is with Mr. A, so I pay to Mr. A. Mr. C says, B, I am now the owner according to this decision in court. And Mr. B says, I don't have anything to do with that case. I am not bound by the case. I have a contract with Mr. A. I pay to Mr. A, period. So Mr. C cannot force Mr. B because they have no contract. And he cannot also drive Mr. B away, even if he has already a judgment, because Mr. B has a contract with Mr. A and the contract has not yet expired. So what will C do? In the filing of the case for recovery of ownership, he will include as party defendants Mr. A
C
and Mr. B.
or B.
Mr. A because he is an indispensable party, claiming ownership over the parcel over the house and lot, and Mr. B because although he is not an indispensable party, he is a necessary party, without whom no final determination of the case may be had. In order to afford complete relief, the necessary party will have to be included. What is the message of Section 6, permissive joinder? As the name implies, permissive means it is not mandatory. So if a party is permissive, necessary, not indispensable, you may or may not include him as party defendant or as party plaintiff, as the case may be. But take note of the additional provision under Section 6, the last phrase. But the court may make such orders that may be just to prevent any plaintiff or defendant from being embarrassed or put to expense, in which he may have no interest. So, the court will also protect persons who are not indispensable parties to determine if they are really needed for complete relief or they are not needed anymore. For instance, in our example, if Mr. B says, well, I'm just a leasing, I will pay to whomever is adjudged by the court as the owner. So there is no need to include him. So he will be severed as party defendant. Well, let's go to Section 7. Section 7 is the exact opposite of Section 6. Because while Section 6 talks about permissive joinder of a party you may or may not join, in Section 7 it talks about compulsory joinder of parties. It's no longer permissive, but you have to include because the joinder is compulsory. And who are these parties who must be included as a party plaintiff or as a party defendant? These are the persons defined in Section 7, compulsory. Parties in interest, without whom no final determination can be had, shall be joined either as plaintiffs or defendants. Compulsory. For instance,
Inom lang ng tubig.
parcel of land is owned by three persons, A, B, and C. Now here is Mr. X, who is claiming ownership over the parcel of land. So he files a case. He cannot just file a case against Mr. A or Mr. A and B, but he has to file a case against all of them. Why? Because they are co-owners, they are real parties in interest, therefore, they must be compulsorily joined. On the other hand, if A, B, and C are the owners of a parcel of land, and here comes Mr. X, who is threatening to enter into the land, then A, B, and C will file the case as plaintiffs against Mr. X. Not only one, A, or not only two, A and B. Why? Because C is also a party in interest, and accordingly, he has to be compulsorily joined as party plaintiff. That is the message of Section 7. Repeat, Section 7 must be studied side by side with Section 6. Because while in Section 6, the joinder is permissive because a person is not a real party in interest, but he must be included, he should be included in order to afford relief, complete relief in the case. So necessary, only permissive. You may or may not include him. In Section 7, you must include him because it is a compulsory joinder. Okay, Section 8, we have discussed that already. A necessary party is one who is not indispensable, but who ought to be joined as a party if complete relief is to be accorded in the case. So, compulsory, indispensable, Section 7, Section 8, necessary, permissive. Okay. Section 9, non-joinder of a necessary party to be pleaded. Okay. The message is simply this. Here is a party which is not indispensable, but necessary in order that complete relief may be had. But then, you deem it wise not to include him because he is not, after all, indispensable. So what will you do? You shall state his name and state why he is not included. And the court will now determine whether it's okay if he's not included or that he must be included in order to afford complete relief. Okay. So that's self-explanatory. The next paragraph would say, failure to comply with the order for his inclusion if the court orders him to be included, the necessary party, then if you do not include him despite the order, then you will be deemed to have waived your right against that party if ever it is found out that you have really a right against that party. Okay, Section 10, unwilling plaintiff. In our previous example, where A, B, and C are co-owners of a parcel of land to which Mr. X threatens to enter and claim. So, in order to erase the cloud of the ownership over the property, A, B, and C should file a case, all of them against Mr. X, because they are indispensable parties, and therefore they must be compulsorily joined because they are the indispensable parties, being co-owners. Now, Mr. C tells A and B, please do not include me in the suit because the daughter of Mr. X is my sweetheart. I cannot file a case against Mr. X because he is my future father-in-law. So what happens now? The law says that all of them must be included as either party plaintiff, or if they are filing the case, or party defendants, and they are the persons against whom the case is to be filed. In our case, they should be party plaintiffs. All of them. They are indispensable. But one of which Mr. C does not want to be included. What will happen? Then Section 10 will apply. Unwilling plaintiff. Mr. C is now what we call an unwilling plaintiff. And what happens? The law says, if the consent of any party who should be joined as plaintiff cannot be obtained, he may be made a defendant. And the reason therefore being stated in the complaint. In short, an unwilling plaintiff will be included as party defendant. Why? Because he has got to be in the case. Because he is a compulsory party. How could he be in the case if he is unwilling? He does not, for any reason, he does not want to be included. But he must be included. So, to solve the matter, his co-plaintiffs will still include him, but this time as party defendant. Then his consent would not be needed because he is a party defendant. But such matter must be stated in your pleading so that the court will not be confused on why he is pleaded as party defendant instead of a party plaintiff. Okay? Section 11 is very easy. The message is simply this. If a party should not be joined but he is misjoined, the case is not to be dismissed by the court, but the court will just issue an order taking him out of the case because he is misjoined as a party. On the other hand, if a person is not joined, but the law requires him to be joined because he is compulsory, he is indispensable, then his non-joinder should not be a cause for dismissal, but the court may order that he be joined in order to have a final determination of the case. So that's very easy. Section 12 is very important. This is class suit. I remember many years ago, there was this promo by Pepsi Cola in order to have big sales. There was this promo that they will print a number in inside the cover of the bottle, the tansan. You remember this tansan has a cork inside cover. If you take out the cork, you will find out the number. And if the number of the cork of the tansan that you have is the winning number, you will win a prize. So people has to buy the product so that they will look at the tansan and see whether they have the winning number. Now there was this glitch. We don't know how it happened because in the whole of the Philippines there's only one of that winning number, or maybe two or three, depending on promotion. But very, very few. In many cases, only one winning number. Only one tansan with the winning number all over a certain territory. Now, there was this glitch where the winning number was printed in so many tansans. We don't know what happened, but let's say I forgot the winning number. Let's just say 369 was the winning number. So it's supposed to be only one bottle cover with 369. But it so happened that there were thousands of tansans bearing the number 369. So when the winning number was released, 369, thousands of persons claimed the prize. In Bohol, there were about 2,000 holders of the tansan, 369 tansan, who claimed the prize. Well, of course, the management did not pay because, according to them, there was a mistake. Only one should win. But then the number is there, 369, and 2,000 people in Bohol were holding that tansan with that number. So these 2,000 persons filed a case in court to collect the prize. Imagine, 2,000 plaintiffs. You will not, in the citation of the names of the plaintiffs alone, you will have 20 pages already. And how do you accommodate 2,000 plaintiffs inside the courtroom? So what is done is these 2,000 alleged winners were all plaintiffs, but they were represented by only a few, let's say 10 representing all of them. And this is known as a class suit. Class suit. So the plaintiffs of 10 represents not only themselves, but all the others who are holders of the winning tansan. This does not mean that you are a class in the second year, and if you file a case, all of you, that is a class suit. That's not the message. So under Article Section 12, when the subject matter of the controversy is one of common and general interest to many persons, so numerous, but it is impractical to join them all. A number of them sufficiently numerous may sue as plaintiffs in a class suit or may defend as defendants in a class suit. Okay, that's section 12. We will continue with section 13 next time. As we have said, Rule 3 has 22 sections. So we will be starting with section 13 next meeting. Okay, thank you very much and good day, everyone.
Te, nanood to na mo? Nanood to na ka? Na may utan diha? Nalago ko. Sirado restaurant to. Sirado restaurant. Sige. Lugsong ko.
This is Untitled Chapter. John Sagano. Sagano remix.
My life is still trying to get up that great big hill of hope for a destination. I realized quickly when I knew I should that the world was made up of this brotherhood of man, or whatever that means. Into it, times when I'm lying in bed, the street getting all what's in my head, and I ain't feeling a little peculiar. Into it, knowing I step outside, and I just get good, but I get real high, and I get on top of my lungs, what's going on? And I say,
John Sagano remix. Jonas Sagino remix. DJ Jonas Sagino remix. DJ Jonas Sagino remix. DJ Jonas Sagino remix. Joanna Sagano remix.
Boy in my mind, 'cause he knows I'm
Shed blood. Say